Welcome to this sixth video in our series of 7, going over our focus areas and recommendations coming out of the release of the MADD South Carolina 2020 Court Monitoring Report called Refusal to Change. My name is Stephen Burritt, Executive Director for MADD South Carolina, and thanks for being with us as we talk about recommendation number 6, which has to deal with judges and magistrates in South Carolina owning the culture of DUI when it comes to these first offense misdemeanor DUI cases. Now, if you didn't know better, you might assume that with every DUI case that comes before a court, there's some sort of a presentation and discussion between the prosecution and defense in open court in front of the judge about the strengths and the weaknesses of the case. However, if you've been in court before, you know actually what happens the overwhelming majority of the time, almost every time, is that things have already been worked out in advance between the prosecution and the defense. And so really all that's happening in open court is just a presentation. This person's going to plead guilty to DUI. We're offering them a plea down to reckless driving. That's what typically just is announced in court, and then the judge is just signing off. So you could be in court for quite a while and come to the assumption that, well, judges really aren't having a whole lot to do with whether people found guilty of DUI or reckless driving or not guilty. However, at a closer look, you realize that is actually not the case. There's a lot more going on in terms of how the judge and the magistrate influences the case. And a lot of it has to do with how they've ruled on past cases. So if prosecutors and defense attorneys and judges, they see each other quite a lot. And in a small community, they're going to be involved in the same cases over and over again. So how a judge has ruled on a case in the past is going to have everything to do with how people are going to treat those cases, bringing it before the judge in the future. So if a judge has been known in the past to say, throw out a DUI video because somebody's feet couldn't be seen while they were being given the HGN test, those prosecutors and those defense attorneys now know this judge expects a perfect video, and it's going to affect how they bring forward every other case where there may be any sort of issue with that video. So it has everything to do with how those cases and what those convictions rate look like. So what we ask is for our judges and magistrates in our state to realize that South Carolina is among the worst when it comes to impaired driving in the country. And we need to figure out everywhere we can make a change. And that includes what happens in the courtroom. So we ask them to take some ownership and accountability for this situation that has occurred and see what they can do differently. It's worth noting that the law only says all tests must be recorded. It does not say perfectly. It does not say if they step out of the camera frame for 2 seconds, then you should throw it out. That's happened largely by judicial interpretation. And it's really why we've gotten to this problem where we're at today, where, again, only one of the 7 counties where we monitored even has a 50% conviction rate. There are a few places in the state where we've gone and we've asked questions about how's the dash cam statute causing a problem for you? And some of the officers have said, our judges here, they don't take those kind of motions. They throw them out. They say that's ridiculous. Just because they're off camera for a second or two, or so they're obscured for a second, doesn't mean I'm going to throw this case out, because clearly they're impaired. We ask for that kind of ownership and accountability. And even if judges and magistrates have not operated that way in the past, they have the right to start looking at things differently. And so we encourage that. The other area of accountability we ask for judges to have is how they handle defense continuation motions. So one thing that many people know is one of the most common tactics for defense in a case is to delay. So they ask for continuations, and the longer the case stretch out, the more problematic it is to get a conviction. If that officer retires or moves and therefore can't be in court, if perhaps a nurse that was involved in a blood draw retires or moves and can't be presented in court, that case is not going to be found guilty of DUI. So as there are turnovers in those professions, if they can delay that case, sometimes it will turn out that they don't have everyone there in the courtroom to make that case. And so that's one of the common tactics that they use. And so we are seeing DUI cases in some areas take on average a year and a half. Sometimes we've seen cases that have been stretched out 4 or 5, 6 years for whatever those reasons might be. But we ask for the judges to make sure that continuations are not being used as a tactic and an abuse simply to get somebody off in the end. And we've heard some stories of some judges and magistrates who have told their defense attorneys, after maybe a repeated request for continuance, to say, no, we're not doing it anymore. Like, we're going to hear this case next week or in 2 weeks or whatever it might be, but to not allow this continue to happen. So we'd love to hear, obviously, stories like that where people are recognizing when something's being used kind of as an abuse as opposed to legitimate reasons for continuations. And finally, we ask for judges and magistrates to look into receiving every bit of training they can on how to preside over a DUI case. As many know, in South Carolina, it's not even required that magistrates have a law degree, so some do and some don't. But DUI cases are incredibly complex, among some of the most complex cases a judge is probably going to preside over. To become a new magistrate, there's only 3 hours of required DUI specific training they have to go through. That's about the same time it takes one officer to make one DUI arrest. So we need to either look at increasing those standards, so for requirements for repeated DUI training, or at least encouraging it heavily, because cases are only getting more complex, especially as drug driving is becoming more of an issue, and they are far more complex. And certainly we did hear stories from officers and prosecutors talking about bringing a case before a judge, getting into the technical aspects of, say, a drug driving case, and being able to tell that clearly the judge was over their head. They just didn't understand anything really about what was being talked about. Again, because very often they're not even lawyers themselves. Sometimes the only person in the room, if it's an officer prosecuting, is the defense attorney, is the only person who has a law degree. And so sometimes they are given too much weight and authority on what they say to be true. And so we just ask for judges to seek actively and to make sure that there's available advanced DUI training so that they can stay knowledgeable and they can preside over cases in a professional manner. So that's some of what we're talking about in terms of what judges and magistrates can do to make a difference. We appreciate you taking the time to watch this video about some of the things that we need to do. So South Carolina will go from refusing to change to actually making a difference that will keep us all safe. Thanks for watching.